Dear students, today we will see a topic from chapter 7, Incorporation Stage. That is the procedure for getting registration certificate or incorporation certificate. In your previous class or in your previous classes, you might have seen the stages in formation of joint stock company. The process of establishing a joint stock company passes through three stages, that is promotion stage, incorporation stage and subscription of capital stage. Read it as a capital stage, there is a mistake. First stage we have seen, that is meaning of promotion, functions of promoters, who are promoters, then different documents prepared by the promoters. Today we will see how company gets registered or how company gets incorporation certificate. In the previous class, we have also seen documents required for registration. When company is getting established, promoters need to prepare 6 documents. They are memorandum of association, articles of association, consent of proposed directors, agreement, statutory declaration, receipt of payment of fees. So these are 6 documents required to be prepared by the promoters and need to be submitted with the registrar of companies with an application. So we'll see incorporation stage. After completing the above said documents, promoters make an application for the incorporation certificate. The application is to be filed with the registrar of companies of the state within which they plan to establish the registered office of the company. It means in which state you are going to start the company, there you need to submit the application with the above said documents with the registrar of companies. The application for registration must be accompanied with the certain documents, that is whatever application you are writing to get the incorporation certificate, you need to attest the following documents. First one is the memorandum of association, the important document of the company which lays down the objectives of the company. It must be duly stamped, signed and witnessed. In case of a public company, at least 7 members must sign it. So if it is a public company, the memorandum of association must be signed by 7 members. If it is a private company, 2 members, that is a signature of 2 members is sufficient. The signatories must also give information about their address, occupation and the number of shares subscribed by them. The members who sign the memorandum of association need to mention or give their full details about their name, address, occupation and how much shares they are going to subscribe from that particular company. The details need to be mentioned. So this is the first document need to be attested with the application. Second one is articles of association. Now articles of associations tells about the rules, regulations to manage the internal working of the company. Now this must be duly stamped and witnessed as in case of the memorandum. However, as stated earlier, a public company may adopt table A, which is a model set of articles. So if it is a public company, they need not prepare articles of association, they can prepare table A. The table A is similar like articles of association only, but instead of preparing articles of association, they have a liberty or they have a privilege to prepare table A. In that case, given in the Companies Act, in that case a statement in lieu of prospectus is submitted instead of articles of association. The third one is written consent of the proposed directors to act as directors and an undertaking to purchase qualification shares. That is, proposed directors will give a written consent and an undertaking that they will buy and pay for qualification shares. The same document need to be attested here. Fourth one is the agreement, if any, with the proposed managing director, manager or whole time director. So the promoters will enter into a contract or an agreement if they appoint managing director, or if they appoint manager, or if they appoint whole time director. The copy of the same agreement need to be submitted. A copy of the registrar's letter approving the name of the company. Now here registrar will approve the name of the company, and he will write a letter. The letter of the registrar that all legal requirements for registration have been complied with. This must be duly signed. Now we have also seen this in our previous class. Statutory declaration, that is a undertaking or declaration must be given that all the formalities are completed. That declaration must be signed by a chartered accountant or a cost accountant, that we have already seen. That declaration must also be submitted with an application. Seventh one is a notice about the exact address of the registered office may also be submitted along with these documents. So where the office is situated, the full address of that office, a notice about that must also be submitted. Now I have already said, if till incorporation stage, if company is unable to finalize the place where the registered office can be situated, if they fail to submit that, they have 30 days time from the receipt of certificate of incorporation. Within 30 days of getting that certification, they can submit it to the registrar. And last one is documentary evidence of payment of registration fees. So when you are getting the company registered, you need to pay the fees. So a proof of payment, that is receipt of payment of registration fees, must also be submitted. So first document is memorandum of association, second one is articles of association, written consent of proposed director, agreement, copy of registrar's letter approving the name of the company, statutory declaration, notice about the registration fees. So these 8 documents need to be submitted to the registrar of companies with an application to get incorporation certificate. Now the registrar, upon submission of the application along with the above said documents, he need to get satisfied that the documents are in order and that all the statutory requirements regarding the registration have been compiled with. When the registrar is satisfied about the completion of formalities for registration, a certificate of incorporation is issued to the company which signify the birth of the company. The certificate of incorporation may therefore be called the birth certificate of the company. So it is understood, once the application is submitted, the registrar will go through with all the formalities. He will find all the documents, whether they are in order or no, whether it is compiled legally or no. He will verify everything, and when he is happy, when he is satisfied with all the submitted things, all the submitted documents with an application, then he will issue a company a certificate called as incorporation certificate. So that certificate signifies the birth of the company. The certificate of incorporation may therefore be called the birth certificate of the company. On the issue of certificate of incorporation, a private company can immediately commence its business. It can raise necessary funds from friends, relatives, or through private arrangements and proceed to start business. So we have seen two types of companies. First one is private company, second one is private company can immediately commence its business activities, but in case of public company, they have to wait till they get the certificate of commencement. They have to complete one more step. They have to raise the capital from the general public. That is the third stage of forming a joint stock company. And then they are supposed to attain, or they are supposed to get the certificate of commencement, and then they can start their business activities. Now we'll see effects of the certificate of incorporation. A company is legally born on the date printed on the certificate of incorporation. It becomes a legal entity with perpetual succession on such a date. Now we have seen the definition of joint stock company. Now joint stock company is an artificial person with a perpetual succession and a common seal. We say it is mentioned in the definition of joint stock company. So once the company gets incorporation certificate, it gets a separate legal existence in the eyes of law. That is why we call company a legal entity with perpetual succession. Perpetual succession in the sense continuous existence. Member may come, member may go, member may die, member may become insolvent, but company will last for a longer period of time, which doesn't take place in case of sole trading concern, in case of partnership firm. The certificate of incorporation is a conclusive evidence of the regularity of the incorporation of a company. So once you get the certificate of incorporation, it is a proof that imagine what would happen to an unsuspecting party with which the company enters into a contract if it is later found that the incorporation of the company was improper and hence invalid. Suppose before getting the incorporation certificate, some illegal activity or some improper thing or invalid thing has taken place, and then the company has taken a birth, or company has received the incorporation certificate. It doesn't matter. Once the company gets the incorporation certificate, that incorporation certificate itself becomes a conclusive evidence of the legal existence of the company. The company will become a legal business entity irrespective of any flaw in its registration. So these are the effects of certificate of incorporation. We need to pay attention here. If it is a private company, soon after getting the incorporation certificate, the private company can immediately commence its business activities. But if it is a public company, they have to complete all the steps or all the stages of formation of joint stock company, and at the end they have to get a certificate of commencement, and then they are allowed to commence its business activities. Thank you.